Good morning or good afternoon, depending on where you may be joining us today. Thank you for attending today's presentation, Mastering I-9 Compliance, How to Navigate Trump-era Policy Shifts. While this session is hosted by CISA, a global leader in background screening and compliance-driven human capital risk management solutions, we're delighted to welcome attendees from across our family of brands, whether you registered through PreCheck, Driver IQ, or one of our other divisions. Thank you for joining us. Today's presentation is presented by WR Immigration, an internationally recognized law firm with 10 offices globally and over 150 professionals. Also, please keep in mind this presentation is intended for informational purposes only. Neither this presentation nor the material presented during the webinar should be construed as legal advice. Thanks again for joining us today. Without further ado, I'm excited to introduce our speaker, Kimberly Robidoux from WR Immigration. Kimberly, please take it away.
Thank you very much, Antique. All right. Good morning or good afternoon to everyone. I'm excited to be talking about this very timely topic. And I want to provide a roadmap of where we're going to go today. So the first thing that I'm going to address is some information about executive orders, then on to I-9 enforcement actions, and then into ICE, HSI, which is Homeland Security Investigation, I-9 audits, and the notice of inspection. And then we're also going to end with a little bit about E-Verify. So a little bonus at the end. Hopefully we'll get there. Okay. We are 2 months into this new administration, and the very first day of the administration, there were several executive orders that were signed. And a few of them did and continue to address issues related to I-9 compliance, as well as immigration, not just immigration where we're talking about deportation issues, but also immigration and how it impacts employers and employees in the workplace. So the executive order titled Securing Our Borders allocates additional resources toward enforcement. And so that is being cast as additional enforcement that works with IS's fraud detection unit, otherwise known as FDNS. And that entails site visits that target employers who sponsor foreign nationals, typically H-1B investigations or audits, as well as audits of L-1 placement of employees. There's also a focus on increased enforcement by the U.S. Department of Labor, and which is investigations that are focused on employers that utilize certain visa programs, such as the H-1B program, and that would be with the public access files that are required to be retained by employers for all individuals that are employed pursuant to H-1B status, as well as E3 and H-1B1. There are also compliance audits that are related to the H-2B program, which is for temporary workers. And then DOL also oversees the PERM process, which is the labor certification application, otherwise known as PERM, which is the first step in the green card process for many individuals. And with employers who sponsor individuals through the PERM application process, they are required to maintain a PERM audit file for a period of at least 5 years. So those investigations are expected to increase by Department of Labor as well. Then we have the I-9 notices of inspection, which are to ensure compliance with the employment eligibility verification. These notices of inspection have been around for a really long time. I know that, remember, they were very active in the 90s and as well as in this century as well, but they're nothing new other than we're expecting an increase in these inspections by Immigration and Customs Enforcement's Homeland Security Investigation section. There also are expected increase in ICE raids, which are beyond that notice of inspection of I-9 compliance. So these are where Immigration and Customs Enforcement may be investigating a particular employer due to criminal activity or other issues that might be ongoing that are related to immigration matters. And then we also are expecting an increase in investigations related to anti-discrimination with the I-9 employment eligibility verification process. And that is conducted by the Department of Justice's Immigrant and Employee Rights Division. So when we're looking at I-9s, There's one side of the law that deals with USCIS promulgation of the regulations and the forms, as well as ICE enforcement of those regulations and requirements for I-9s. And then on the other side of the statute, we have the anti-discrimination provisions that are enforced by Department of Justice's IER section. The second executive order that I wanted to touch on briefly is the executive order titled Protecting the American People Against Invasion. And this is to enhance national security by, one, revoking the Biden era immigration policies. And some of the examples that we see with this is the termination of TPS for certain individuals. Right now, that has been for Haitians and Venezuelans. This is also going to be seen with establishing Department of Homeland Security task forces to combat crime at the border. And then it's also, this executive order also focuses on encouraging the deportation of illegal immigrants. One of the things that we're seeing with respect to revoking Biden era immigration policies, as well as essentially encouraging the deportation of illegal immigrants, is with the announcement yesterday that Department of Homeland Security has or is ending the parole programs for Cuba, Haiti, Nicaragua, and Venezuela, hence CHNV. Those programs are going to be terminated as of April 24th. And any employment authorization documentation that's based on that parole program will also be terminated as of April 24th. Stay tuned to see what happens with that. We're expecting some litigation as we have litigation against the termination of Haiti TPS and the termination of Venezuela TPS. So there's a lot of moving pieces right now with what's happening in this employment and immigration enforcement arena. So those are some things to stay on top of and aware of. So I'm going to move into talking about ICE investigations. And we're going to talk first just about ICE overall, not in the I-9 audit world, but when ICE comes knocking on the door, if they are doing some type of investigation or they're looking for a particular individual. So some things to know: federal agents, they enter the public areas of a workplace, but they must have a judicial warrant or consent from a company representative to enter non-public areas. So I'm sure a lot of people have heard a lot of information about what to do with respect to ICE showing up at a workplace. There are a lot of organizations that have been putting signs up in order to designate what is the public area and what is a private or non-public area, as well as training their team members what to do in the event that ICE does come to a workplace. Some of the key things to look out for are the types of warrants, right? Judicial warrants are those that are signed by a judge, and that's a warrant where the government, but in this particular case where I'm talking about ICE, is looking for specific documents, specific individuals even. And by doing so, they're saying, we have gone to a judge and the judge has signed off on the reasons for which we are requesting this information and or documentation from a company. The judicial warrants, I'll give a little bit more information on that with the next slide where I have a sample. And so in contrast to the judicial warrants, we have administrative warrants, and those are signed by an agency official, not by a judge. So employers are technically not required to consent to administrative warrants. The federal agent will then need to go to a judge to provide information to that judge as to why the warrant is necessary to obtain that specific information, documentation, or individual from a particular workplace. So a company can accept the judicial warrant and not consent to the search, and those are nuances to be discussed in developing the plan that the company is going to pursue if ICE does come knocking on the door. So in those situations, ICE will still conduct the search, but the company representative or the company itself can later challenge that search if there are grounds to do. So just some things to keep in mind with judicial versus administrative warrants. So the sample warrants that I have here is, I think on your right side, there's the document that says United States District Court, it lists United States of America versus the defendant. There's the arrest warrant. You can see highlighted in yellow that it's been signed by a judge. This is a judicial warrant. And this is something that, again, a company cannot say, no, you cannot come onto our premises. But with a judicial warrant, there are some things to keep in mind, which I'm going to talk about as well. And in contrast, over on the left side, we have the U.S. Department of Homeland Security warrant for arrest of an alien, or it could be warrant for certain documentation. And this is signed off by, as you can see there, it's an authorized inspection or immigration officer. It could be an ICE officer, but this is something that is issued by the agency. And it really is something to review with the appropriate person at the company in conjunction with an attorney as with regard to, are we going to turn over this information and or documentation that's being requested? Is it a simple enough request? Or do we want to fight this and tell the agency, nope, we're not going to comply. You'll need to get a judicial warrant in order for us to provide any documentation. And again, that's something to decide in conjunction with counsel. So the other things that we see in addition to warrants are immigration enforcement subpoenas. These can be issued by ICE even when there is not an I-9 audit. It could be asking for, with what we've been seeing recently, information about personnel records for individuals or payroll records. So again, with an enforcement subpoena, it is not something that a company is required to abide by if issued by ICE. But again, discuss that with with counsel, such as an immigration attorney or with in-house legal counsel. On the right, we have an immigration enforcement subpoena with several items. This is what is typically included with an I-9 notice of inspection. And so if this is issued in conjunction with an I-9 notice of inspection, then these documents and information typically have to be turned over as part of that I-9 investigation, or there could be potential issues that could lead to fines and or penalties. So these are some of the documents just to be aware of with a potential ICE visit. So if ICE does come knocking on the door and it is not an I-9 audit, right? So I'm going to emphasize that this is not applicable with I-9 audits, but with ICE coming to a workplace, there are some things that you need to know and that you would want to have a plan in place. And this is something that companies can put their individual plan in place based on their unique situation and how the company is structured. But the first thing is in this action plan, you want to provide questions that the individual, so that first company representative that might be engaged with ICE should ask of the agents. So they want to know, what is the agent's name, their badge number, their contact information. And it's also important for that company representative to review the document in order to determine next steps. So if the agent does not have any document, then the company representative may tell the agent that they cannot provide any information without a warrant, right? So no document at all. There's no obligation to talk to that agent. So a team member or multiple team members should be identified in your action plan as the main contact to review the situation and interact with the agents, as well as to contact an attorney, right? So you want to make sure that you have people in place that are going to be the go-to people in order to do this initial or secondary review of the document and help provide for guidance and next actions to be made by the company. So what happens with respect to search warrants, right? If there's a warrant that's issued, again, the company representative needs to review that document, make sure that it is signed by a judge, and then it specifies the scope and the time frame. So it's really important to make sure that the appropriate entity is noted on the warrant, that the particular location is noted on the warrant, and the time with respect to it's on this day, or it's within a range of days. Because if the warrant is for a different entity or it's for a different site, then that's when a company representative can refuse the warrant because it is not appropriate for the place or the time or the scope. Company representatives also should not consent beyond the scope of the warrant. So if the warrant is only asking for certain documents and ICE asks for more, it's perfectly acceptable to say, no, that's outside the scope of the warrant. You also want to have a company representative assigned to document ICE's actions, to review or itemize the records that have been seized by the government, and then also consult the legal team before making any statements to ICE agents. So it's really important that a company representative should not give any statements to federal agents or allow themselves to be interrogated without consulting an attorney. You can also inform employees that they may choose whether or not to talk with federal agents, and the company representative should never, ever direct employees to refuse to speak to agents when questioned. So it's really important that there's some protection there, that individuals can choose to adhere to their right to remain silent. And that is definitely something that they have a right to do. But company representatives need to be really careful about any information that they provide to the government. And then also, company representatives, this is really important, should never hide any employees or assist them in leaving the premises without permission from the agents. So that's really important, as that could be construed as aiding and abetting or result in criminal penalties on that company representative. So those are some key things to think about in action plans. There's a lot of great material out there from the ACLU and the National Immigration Law Center, as well as your own internal counsel and an immigration attorney, if you want to create a plan that is comprehensive and focuses on your specific situation. All right, so I'm going to turn away from the ICE enforcement actions and focus strictly on the ICE enforcement actions with respect to I-9 audits. So we're going to move forward with I-9 audits, which is a review of the I-9 employment eligibility verification forms that all employers are required to maintain for all active employees that have been hired since November of 1986. So I-9s need to be in place for every single active employee of the company. So one of the things that we look at is, now you have your I-9s, you are potentially subject to an audit by ICE, Homeland Security investigations. So are there going to be an increase in I-9 audits this fiscal year, which is fiscal year 2025? Yes, the expectation is that there will be a significant increase in I-9 audits as well as worksite compliance. And ICE Homeland Security Investigations has noted that they plan to re-audit companies that have been audited in the past several years. So there definitely is that expectation to have an increase over what we've seen the last 3 to 4 years with respect to ICE audits. We also expect for there to be targeted areas and industries. Those tend to be the usual, and I don't mean that in a derogatory way, but typically there are certain industries that are almost always targeted by ICE for I-9 audits, and those are companies or industries in the manufacturing sector, the janitorial sector, staffing agencies, as well as construction and hospitality. So those are the main industries that we typically see targeted by ICE for these I-9 notices of inspection. There also are targets for industries or companies that are considered within the national security or critical infrastructure. So that's where we tend to see some construction companies that might be considered under critical infrastructure. So just some things to keep in mind with respect to those areas. So the I-9 audits during the prior Trump administration, Trump 1.0, we had, with that last year in which he was in office, there were over 6,000 I-9 notices of inspection. And then after that, part of this was as a result of COVID. Another part of it was a result of the Biden administration's refocusing of their efforts with respect to worksite compliance. And we had in fiscal year 2022, we had 624 I-9 audits. In fiscal year 2023, that was decreased to 301. And then in fiscal year 2024, we had 264. So a significant decrease in the audits during the Biden administration. One of the things that the Biden administration did do with respect to I-9 audits is that they were driven by leads, meaning tips and complaints. So rather than sending out I-9 notices of inspection to a lot of different companies just through a random drawing, they actually went and focused on companies that had been brought to their attention via tips and or complaints. There also was a focus on labor exploitation. So Homeland Security investigations was very much focused on investigating organizations, and again, through tips and complaints that were involved with the exploitation of the workforce. So exploitation of foreign nationals or even exploitation of US citizens, exploitation of children. So that became a primary focus with I-9 audits. So I had a couple of examples of the warrants, and now this is an example of what a notice of inspection looks like. The notices of inspection now that we had just recently seen with some of the audits that occurred beginning in the middle of February is there's additional information in the notice of inspection that is asking specifically for information and documentation if a company utilizes I-9 software programs to complete their I-9s in their I-9 process. There also has been added language that states that an employer may not make any corrections to the Forms I-9 between the time that they receive the notice of inspection and the time that they turn over the I-9s to ICE for the audit review. There's also a caveat in there that no additional I-9s can be created for those employees where there might be a missing I-9. So we say if you notice that there's an I-9 missing for an employee, you may definitely complete that I-9 for the employee and turn it over to ICE in response to your notice of inspection, and then leave it to counsel to potentially negotiate a fine down based on the fact that the government isn't counting that I-9 as having been submitted. So there are tactics that can be utilized, but there's no legal reason that an employer cannot complete I-9s for employees where they find once they get the notice of inspection that they're missing the Form I-9 and then turn it over as part of the audit. So this is a notice of inspection that you would expect to see. It says to an employer that you can waive the 3-day requirement. Never ever waive the 3-day requirement. So whoever you have, that might be the first person that would be meeting this ICE agent or auditor, make sure that they know to not waive that 3-day requirement. You want to make sure you have as much time as possible to gather your documentation. Okay, so this flow chart, I find it rather useful as well as a little intimidating sometimes. This is directly from the Immigration and Customs Enforcement's website. It was just recently updated in the last few weeks. So this is the most recent process, a flow chart that we were able to find directly from the government. So this goes along with what happens when there is an ICE notice of inspection. So the first thing, as I mentioned, is that the agent or auditor, typically the two of them come together. Typically ICE agents go in pairs. There's an auditor, which is the an agent who's actually reviewing all of the documentation. And then there's a special agent who is there with the auditor because they always come in pairs. So they will issue that notice of inspection. The company representative will sign the certificate of service, and then the clock starts. So that notice of inspection will provide the date that the I-9s and supporting documentation are required to be provided to that ICE auditor. So what we're typically seeing with that notice of inspection is that there is the contact in person by the ICE agent and auditor. I have not seen in a long time that notice of inspection sent via mail or email, but it's typically in person. So once you receive the notice of inspection, then the company is going to go through all of the Forms I-9, determine what is going to be everything that needs to be provided to the HSI individual, and then provide those documents. Those documents might be provided as the originals with the ICE agent or auditor coming to pick them up from the company, or sometimes the company representative or an attorney will go to the actual federal building and turn the documents over. And what we've been seeing more often is that ICE wants to have the documents sent to them either on a thumb drive or digitally so that they can review them that way. So it's really important to understand how is and does ICE want to collect those documents. So the auditor is going to do an initial review of the forms I-9. And if there are any violations, they can issue what's called a notice of substantive or technical failures. And those are items that can be corrected by the company. So it might be a date of birth for the employee that's missing in section 1, and the employee will need to make that correction in section 1, initial and date it. It could be that the date of hire was missing in the certification section of section 2, and the employer can make that correction, initial and date it. So that notice of technical or procedural failures is issued by ICE. You will have 10 business days to comply with that, basically make those corrections. If those corrections are made, then typically ICE will not fine for those corrections or for those violations. If there are violations that are not corrected or that are substantive, then ICE will not provide for any option to make corrections because corrections cannot be done. And once there's the notice of substantive or technical failures, the next notice that ICE can issue is typically the notice of suspect documents, which is a list of the individual employees and the related USCIS number, alien registration number, or social security number that ICE has determined do not match. So ICE will say, here's your notice of suspect documents, meaning we believe that the individuals on this list do not have valid authorization to work in the US. And so within 10 business days, an employer is required to contact the employees, ask them for a valid List A or List C document to prove their current employment authorization. And if they are unable to do so, then their employment will need to be terminated. If an employee does turn over a document, that document needs to be provided to the ICE agent or auditor. They will do a review, and during that time, you can continue to employ that individual and wait for confirmation from ICE as to whether that document is valid or not. Another notice that can be issued is a notice of discrepancy. And most of the time, what we see with that is that it's individuals who are naturalized US citizens, and for some reason, their status as a citizen was not updated in DHS or SSA. So that's where the individuals need to provide information to prove that they are authorized to work in the US. So those are the typical notices that are received. Once that is completed, then the auditor will go back and review what substantive violations are going to be fined, as well as also review if there are any technical or procedural failures that were not corrected. Those can be fined as well. If there aren't any violations, or if the violations are minimal, ICE can issue a warning notice, which pretty much says, there were some violations, just don't do this again. Or they can issue a notice of intent to fine. And once there's a notice of intent to fine, that is when a company can either pay the fine or ask for a hearing and then enter negotiations with ICE counsel in order to reduce the fine. If there is no settlement reached, or if a company just doesn't want to engage in settlement, you can go directly to a hearing with the Office of Chief Administrative Hearing Officer. So that's the I-9 notice of inspection life cycle. Very quickly, there's a lot more details that go on with an I-9 audit. So I'm going to move on to what happens with respect to penalties. So if an employer violates the law with respect to the I-9 employment eligibility verification process, there might be civil fines. There can be criminal penalties, which is typically where there's a pattern or practice of violations. There can be debarment from government contracts. There also could be a court order requiring the payment of back pay to individuals that may have been deemed discriminated against. And a lot of times, this usually goes with an investigation that is conducted by Department of Justice's Immigrant and Employee Rights section, as well as this next one, which is a court order requiring the employer to hire the individual discriminated against. That typically would be a penalty if you were subject to an IAR investigation. And so what are these penalties or the fines? The fines go up, believe it or not, they go up every single year. So in 2025, based on the Federal Register that was recently released, the I-9 paperwork violations, and these are paperwork violations for first offense, is $288 to $2,861. And I'll explain a little bit more about that range. But if there are errors or violations with respect to recruiting, referral, and rehiring violations, the penalties are between $716 and $5,724. And this is with respect to knowingly employing or continuing to employ unauthorized workers. Or as this current administration is quoting or stating, they're going back to the older terminology, which is illegal aliens, right? So those are for the fines for the first offense. If there's a second or subsequent offenses, the penalty range goes up significantly. So it starts at around $5,700 up to as much as $28,000, and that's per Form I-9. With these fines, just to give a little bit of background information in comparison, in fiscal year 2019, ICE conducted 5,981 I-9 inspections, and they reached $14.3 million in fines, penalties, and forfeitures. That was fiscal year 2019. And then in fiscal year 2024, by contrast, Homeland Security investigations conducted only 264 I-9 inspections, and that resulted in notices of intent to fine that totaled more than $17 million. And they cited in their annual report that $4.5 million of those penalties has been collected thus far. So you can see that almost 6,000 inspections, $14.3 million. And then with very targeted inspections, we went down to 264 with $17 million in fines. So there being the Homeland Security investigations focusing in on, quote unquote, the bad actors, they were able to target fewer employers, conduct fewer investigations, and still recoup in terms of fines almost or greater than what they did when they were excessive investigations. I mentioned that there's that range with penalties. So what does that mean? The sample that I have here is from 2023, and I use this only because it's the last matrix that we've received directly from Immigration and Customs Enforcement. So I want to use something that has been provided directly by the government. And this was attached to a notice of inspection when they issued the notice of intent to fine. So what the government does is they look at the percentage of I-9s that have violations. So if you have violations of 0 to 9% of the forms I-9, for the first offense, the fine for each I-9 that has a violation is $272. But when you look at if there are 50% or more of the forms I-9 that have violations, and these are substantive violations or technical violations that have not been corrected, you're looking at $2,296 per I-9 that has a violation. So that's why there's a range in the penalties. The range increases the greater the number or percentage of forms I-9 that have violations. And then the other thing to look at is criminal penalties, right? So for criminal penalties, it's typically situations where an employer has been engaged in a pattern or practice of hiring, recruiting, or referring for a fee unauthorized aliens or unauthorized workers. So that fine can be up to $3,000 for each individual that is unauthorized, or up to 6 months in prison for the pattern and practice of hiring or retaining individuals that don't have authorization to work in the US. So those are the criminal penalties, which we typically have seen in very egregious cases. However, going forward, we're anticipating that there might be more criminal actions taken of employers, given what we talked about with the executive orders of the government targeting or focusing on immigration enforcement and targeting employers who are hiring or employing individuals that don't have authorization to work in the US. So there's a part of the I-9 process that we rarely talk about, and that is with respect to harboring. And harboring is not completely defined. It's defined in case law, but it essentially is hiring and continuing to employ a person while knowing or recklessly disregarding the fact that the individual is an illegal alien. Harboring can also include paying an individual as a contractor when the employer knows or recklessly disregards the fact that the contractor is an illegal alien, again, an undocumented worker, or disregards that the contractor is employing or engaging an unauthorized worker, an illegal alien. So in these situations, the government can do an investigation to determine if a company is harboring illegal aliens, in which case the penalty rises to a criminal felony violation. Why am I talking about harboring when we really haven't had many harboring cases in the past? And one of the reasons is because on February 5th of this year, the U.S. Attorney General issued a memo that's titled General Policy Regarding Charging, Plea Negotiations, and Sentencing. And it didn't seem to apply to us in the I-9 world, but there is a reference with respect to the statute that covers harboring. So there is some concern that if an employer has a notice of suspect documents and does not terminate the individuals that cannot provide updated documentation to prove work authorization within those 10 business days that they are given with a notice of suspect documents, it is very possible that the government could then look at a harboring charge against the company or a particular company representative. So that is definitely something to keep in the back of your mind, in the back of our minds, is what we're looking at, just in paying attention to how this might play out as these notices of inspection and investigations continue. So one of the cases that we've seen just recently that focus on harboring, and this is a pretty egregious case, but it's Abby's Bakery and Dolce's Cafe in Texas. Those entities are owned by the same individuals. And what happened is that there was an investigation by ICE. They found through a tip, I believe, that there were employees of Abby's Bakery that were living in a place that was in a plaza right next door or in the vicinity of the restaurant. So ICE took the approach during the investigation that these individuals were being harbored by the company owners who knowingly had the individuals living in that location, knew that they didn't have authorization to work, and that they also were exploiting them by paying them very low wages. So again, that's a really egregious example, but it's the first one that we've seen during this administration with a focus on coming down on employers that are employing individuals who are unauthorized to work in the US. Okay, so how do you protect yourself? Be prepared for an HSI audit. You want to conduct an internal I-9 audit, preferably with an experienced attorney so that there's privilege attached to any findings that come out of that audit. You want to renew your I-9 policies and processes. So take a look at what is your standard operating procedure. Do the people that are engaged in the I-9 process know definitively what their role is? If someone is out of the office, who's the backup person to assist with the I-9 process, and make sure that all the employees that handle the I-9 process are trained. And we would recommend training them at least once a year if not twice a year. And why continue to do the training at least once a year? Things change with the I-9 process. There are changes with respect to work authorization documents. There's changes to what might be a focus by the government with respect to violations, but primarily just to make sure that everybody is aware of the process, that they know what needs to be done. They know how to handle tricky situations that might come up or who to contact if there's a situation where the document that's presented doesn't look like a familiar document or isn't listed specifically on the I-9 list of acceptable documents, so that there aren't any issues with turning an employee away that has an appropriate document, but it just an employer can't tell because it's something that's new or different or nuanced. And then also prepare a clear process in the event that HSI does serve a notice of inspection. So you want to make sure that you are prepared in advance of an HSI audit. So you want to make sure that you have people identified who are going to respond, who's going to pull the I-9, either their paper I-9s or they're in an electronic I-9 system, who's going to pull that documentation, provide to ICE, who's going to make sure that all the audit trails are included and that the documentation with respect to the I-9, the I-9 verification process is included for the HSI agent. And then all the additional supporting documentation that ICE might request with that immigration enforcement subpoena, such as payroll records. We ask, why payroll records? Well, because the Homeland Security Investigations wants to make sure that they do, in fact, have an I-9 for every single active employee. They're also going to compare the date of first employment or the date of hire. So that's how they can determine if the I-9 was completed within the appropriate time frame, right? That no later than the end of the first day for Section 1 and no later than the end of the third business day for Section 2. And that's typically referred to as the Thursday rule, meaning if somebody starts employment on Monday, you have until the end of Thursday to complete Section 2 of the Form I-9. So again, there's a lot of documentation that can be requested in this subpoena, and not just the payroll records, but the reports that have been submitted to the government with respect to payroll. They can ask for the business license. They can ask for documentation about the E-Verify process and all of the E-Verify cases, either the case number or the report, as well as asking for, does the company engage with any contractors? If so, who? What is the process? Is there a handbook, et cetera? So the list can go on and on with what might be required. And then if you're going to conduct an internal audit, you want to determine the purpose of the audit. Is it to get a sense of any particular violations that can be cleaned up? Is it just to get an overall 30,000-foot view of how bad are the I-9s or how amazing are the I-9s? And you want to determine the scope of the I-9 audit internally. So you can either just audit a subset or you can audit all of your I-9s. Again, when this is internal, you have the time that you can set forth with respect to how long is this project going to take versus the 3 days that you have with a government issued audit. You also might want to engage in communication with employees, especially if during your internal audit, you're going to need to reach out to employees to complete or revise or update Section 1 or Section 2 needs to be updated. Let's say you find that someone's work authorization is expired and you need to reach out for updated work authorization. So you want to ensure that you have communication for employees. Again, avoid discrimination and retaliation. So you want to make sure that you're very clear on what your process and communication is going to be, and then create a process for correcting those errors that are found on the I-9 during the audit. The last section that we're going to look at just briefly is E-Verify. E-Verify is not yet nationally mandated, but if you are enrolled in E-Verify, you've probably seen communications from E-Verify about their new E-Verify Plus program. Initially, this was known as Next Gen. It is going to be the future of I-9 and E-Verify. Right now, it's essentially in a period of of inspection of beta testing, but it's beyond beta testing, but they're looking to see how this is going to be able to be rolled out to larger employers and more employers. They're looking at some of the limitations of the system, but it is important to know that the E-Verify Plus process is not a replacement for I-9. It is only available for companies that do direct E-Verify with the USCIS and not through a web service provider. And one of the major drawbacks is that the audit trail that is produced with the E-Verify Plus is not yet approved by ICE. So just some things to consider before jumping into E-Verify Plus. And then another thing I just wanted to mention, just be aware of, there are state E-Verify laws. Some laws require certain employers to participate in E-Verify. And then there are some states that provide for extra protection to workers when an employer participates in E-Verify. The most recent is Illinois, their law just went into effect this past January. So just be aware that if you have employees in certain states, you might, based on the law, be required to participate in E-Verify for that particular state. And then for some states where there is mandatory E-Verify enrollment participation by certain employers, they have been very active with their state investigations, and that includes Florida, North Carolina, and Tennessee. So just be aware that there are increased investigations by state agencies of employers with respect to their E-Verify compliance. And here, which you'll receive in the slide deck, there are some great resources. The Handbook for Employers, I recommend tabbing that, bookmarking it. Don't print it out as a PDF because it does get updated by USCIS regularly. So you want to make sure that you're looking at the most recent version. So my recommendation is always go to the version that's online. There's also I-9 Central, which works in combination with the Handbook for Employers. If you're enrolled in E-Verify, there's the E-Verify website, which has a lot of great information on it. And then, as I mentioned, Department of Justice's Immigrant Employee Rights section. They have a lot of resources as well as hotline numbers. So if there's a question about a document that you don't know if it's acceptable or not, that might be a reason to reach out to the employer hotline at IER for some guidance. And with that, I am going to look at, I know we had some questions that came through for everybody. So let me just.
Yeah, we have 8 minutes left, so I could read out some questions for you.
Okay, great. Thank you.
So I have one question here. Can you verify documents for the I-9 before the 3 days, or does it have to be in the 3 days?
That's a great question. So it's no later than the end of the third business day. So an employer can definitely have a process in which you complete the Form I-9 prior to the first day of employment. And that's acceptable as long as you apply that consistently for all new hires. Don't treat people differently, but the requirement is to complete Section 2 no later than the end of the third business day. So you can definitely complete it before the individual starts employment, as long as there is an offer and acceptance of employment.
Did you make copies of the documents if you have to turn over the originals?
Absolutely. So if you are required to turn the original I-9s over to ICE during a notice of inspection, you definitely want to make sure that you retain copies of those documents. And you also want to make sure that you get a receipt from ICE with respect to what they have taken. So if they count them and they say there's 565 I-9s here and you have counted 600, then you can definitely sit there with the auditor to make sure that the receipt that you receive is accurate with respect to the number of I-9s that they're taking. And there could be some confusion over, are they counting the employees? In which case, an employee might have multiple I-9s or multiple Section 3, which is now Supplement B, or are they counting the actual I-9s? So that's definitely something you want to clarify before you turn everything over.
If a green card is expired, do we need to re-verify the documents?
No, typically, for U.S. citizens and U.S. lawful permanent residents, you are not going to re-verify their work authorization. There are limited circumstances in which the work authorization for a permanent resident does need to be re-verified. If a permanent resident provides an unexpired permanent resident card for evidence of list day, that is never, ever re-verified. But if a permanent resident provides an expired green card or permanent resident card plus a receipt notice, it depends on the circumstance whether or not work authorization needs to be re-verified. So I'm going to direct you to the M274 Handbook for Employers, which has a great section on when you do need to re-verify the work authorization for a permanent resident.
If an employee provided fake documents when hired and an employer believes them to be authentic, will this result in a substantive violation?
So an employer is not required to be a law enforcement officer. So as long as the document appeared to be reasonable on its face, then there could be a situation where that individual is noted in the notice of suspect documents, as long as that individual is terminated during that 10-day period of time. If they cannot provide valid work authorization, then the company should not be fined for accepting that document that they believed honestly was legitimate or valid.
Can employees fill out Section 1 prior to an employee starting to help speed the onboarding process?
Yes, an employee may complete Section 1 prior to their first day of employment, as long as there has been an offer and acceptance of employment, and that's the employer's consistent practice.
What steps should employee take if they find that there are I-9s missing for some employees?
So if you determine that I-9s are missing for employees, then I recommend having a written communication to the individual saying that during the course of the company's internal audit, it was determined that there is no I-9 on file, and we need your assistance with completing the Form I-9. Provide a date by which the individual has to complete Section 1. And then I typically say, treat it as an original I-9, so give the employee 3 business days to provide the documentation for Section 2 to complete Section 2.
Does an employer need to retain hard copies of all their I-9s if they are scanned?
If the I-9s are scanned, you need to make sure that they are in compliance with the electronic retention rules and regulations. If they are not, then you definitely want to keep hard copies. So I wouldn't recommend purging or shredding any hard copies of the I-9 documents that you've scanned unless you have confirmed in consultation, typically with an immigration attorney, that the scanned documents meet the government's retention regulations.
How long do we need to keep I-9s after the employee is no longer with the company?
So I-9s need to be kept for all active employees. And then only after an employee's employment has been terminated can you determine when that Form I-9 can be purged. So it's 3 years after the date of hire or 1 year after the date of termination, whichever is the later date. And so you can actually document that on the Form I-9 or in your system, and then purge the document accordingly for that terminated employee.
What can we do for DACA workers who are waiting for their new permits to come?
So for DACA individuals, if their EAD card has expired, their work authorization has expired, and unfortunately they cannot benefit from the automatic 540-day extension of work authorization. So for those individuals, once their employment authorization expires, there is typically the guidance is that their employment is terminated and then you can rehire them. There might be a possible solution of placing them on an unpaid leave of absence, but I recommend speaking with counsel before taking that action.
All right. So unfortunately, we are out of time. If we couldn't get to your questions, please feel free to email us and we will try to answer them. Thank you again for joining us today, Kimberly. I'd like to thank you for being with us and providing us with such an informative and timely presentation. To our attendees, if you have questions about our background check solutions, you can scan the QR code on the screen right now to chat with one of our screening experts.